Good morning, everybody. Thank you so much for joining us. My name is Emily Garfinkel. I am the Membership and Programs Manager here at the Connecticut League of History Organizations. I am also joined here by our Executive Director, Amherst Williams, who will also be present for this presentation today. So this is our third in the series of three for the Intellectual Property series, Introduction to Creative Commons Licenses and Tools. So just as a heads up, this will be recorded and it will be available on our YouTube channel afterwards. I will also be sending a follow-up email to everybody who is registered for this, not just with this recording link, but with the previous two sessions as well. So that way you can go back and refresh and watch at your convenience. So we are very excited to have Creative Commons once again, and thank you to Mike at Connecticut Humanities for setting up this collaboration. We are so excited and also sad that this is the final session in this series, but we are so grateful to have such wonderful experts here, and of course for all of your support for being here. So we will get started in just a moment. If you have any questions that come up during the presentation, feel free to drop them in the chat, and we will address them as the presentation goes on, and we will have space for questions as well. So without further ado, I will pass this on to Mike Kamizis at Connecticut Humanities. Thank you so much, everybody.
Thank you, Emily. So I'm trying to share my screen. There we go. Okay, awesome. Hi, everyone. My name is Mike Kamizis. I'm the manager for partnerships and projects here at Connecticut Humanities. And thank you for joining us. And thank you for everyone who made all three. This has been really great. We were talking today, Brigitte and I, about how we started this conversation about a year ago and about how we're going to continue this relationship with Creative Commons into the future. So you might be asking, why is Connecticut Humanities involved in intellectual property? And for those of you who've been here before, you've seen this presentation, but we've started working on IP in order to encourage open sharing of projects and programs created through our grant funding, which furthers our mission of ensuring the public humanities continue to inspire storytelling, lifelong learning, inform public dialogue, and civic engagement. This has been something that has been in our organization for a while. How do we fund projects and then use that kind of content in other ways? And we figured out an IP policy might be the way to go. So we want to promote open sharing and reuse of content. We want credit and protection for the organizations that we fund for their projects, because they put a lot of hard work into it. And also, we're going to be licensing our own work. We're going to be working with our digital humanities department for licensing content posted on ConnecticutHistory.org. So the project timeline, just real quick. Our policy was adopted in 2022 in October, developed in the summer. We got community feedback in the fall. It was adopted by our board, and then it was reviewed by an IP lawyer in the winter of 22. For granting, what does this mean? What does the policy mean? It will go into effect for our competitive grant lines starting January 1st. We have an IP webpage not coming soon. It is up. I will share the link after this, where you can read the policy. There's some more content. There will also be these videos. You'll be able to download an explainer document and also contact information for me if you have any questions. We will be updating grant guidelines this month to include language about this, and I'm always here to talk more about IP. Further, for education for this year and next year, we have these 3 webinars. This is the last one. We will be having a CTH staff workshop with Creative Commons in the fall, and we will include members from the league and from other organizations around the state that deal with digital content primarily, to kind of continue these efforts to build understanding of IP and open access in our organizations. Also looking at a higher state level to bring together the Connecticut State College and University System, the Office of the Arts, people who work in open climate, open science, to kind of a roundtable discussion to kind of continue these conversations and find intersections where open access makes sense for our different sectors. So keep an eye out for that. We will also be having a working group of people who are interested in open access and cultural heritage that will be available. We're still trying to figure out how that's going to work, but we're trying to create a place you can turn with your sticky questions about IP, and hopefully offer you some guidance. Also knowing we're not lawyers. We are just working in this sector, and we really want to help. So without further ado, I would like to introduce again, sorry, give me 1 second here. There we go. Again, Brigitte Vizina from Creative Commons, who is our presenter today. She's the Director of Policy and Open Culture. Brigitte is passionate about all things spanning culture, arts, handicraft, traditions, fashion, and of course, copyright law and policy. She gets a kick out of tackling the fuzzy legal and policy issues that stand in the way of access, use, reuse, and remix of culture, information, and knowledge. Before joining Creative Commons, she worked for a decade as a legal officer at WIPO and then ran her own consultancy advising Europeana, Spark Europe, and others on copyright matters. Currently located in the Netherlands, where she lives with her husband and 2 kids, Brigitte grew up living in 8 different countries across North America, Africa, and Europe, but Montreal is where she proudly comes from. Brigitte is a fellow at the Canadian think tank Center for International Governance Innovation. She holds a bachelor's degree in law from the University of Montreal and a master's in law from Georgetown University. She's also a member of the Bar of Quebec since 2003. So I'm happy to hand it off to Brigitte to take us for the rest of our program.
Thank you, Mike, for the introduction, and thank you for organizing these webinar series. It's always a great pleasure for me to be here with you and all the participants. Sadly, it's the last session we have together, but like Mike said, there is going to be a staff workshop, and Jocelyn Miara, who's the Open Culture Manager at Creative Commons and who's here in this session, will attend. So if you have any questions, feel free to ask them in the chat throughout the presentation, and me or Jocelyn will be able to tackle them at some point. So just to recap on what we've done in the first 2 sessions and put this third one into context. The first one was really about setting the basics around copyright law, how copyright law is governing the creation, but also access to cultural heritage, and how it is sometimes erecting huge barriers, and how Creative Commons as an organization, as a set of licenses and tools, have been created to overcome these barriers to sharing knowledge, to sharing culture, to sharing all sorts of creative content online. So that was the first session where we looked at copyright. We looked at the birth of Creative Commons, and we also looked at the different fields of open. So open education, open science, and where open solutions are available to enhance various fields. The second session was really a deeper dive into open culture. That's the program that Jocelyn and I are leading at Creative Commons. And it gave an overview of what open culture is, what are its aims, its goals, its objectives, and how it can be implemented on a very practical level. And now this third session is about our Creative Commons licenses and tools. So it's a bit more technical than the other sessions where we discuss ideas and concepts on a rather high level. This one will be really focused on the different licenses that we offer and what they aim to achieve, how they can be used as a creator. So someone who is an artist, a musician, a photographer, whatever it may be, or also a cultural heritage institution that has content, and for those that want to share. We also look at them from the perspective of a user, someone who comes across openly licensed content. What are the questions that need to be answered in order to use them properly? I'm hoping to end this session with a little interactive activity. So I hope you can stick around to have some fun with openly licensed content and be a little bit creative as we all learn the ropes of open licensing. So I'll start sharing my screen so that you can follow along. Can you let me know if you can see the slides? Yes, you can see the opening slide. Yes, great. All right, so today's agenda, like I said, is rather technical, really focused on what the licenses look like, their design, the terminology. So we'll use words like terms and conditions and restrictions and icons. We'll get through all that vocabulary. We'll go through the license scope, how they interact with copyright law, how long they last, so different types of licenses, and how they can be enforced in court. Then, like I said, we'll be looking at using open content, so the content that is created by others, how we can use it and reuse it in different contexts. And then the third part will be applying a CC license to works in which we hold copyright, or for cultural heritage institutions where there's agreement with the copyright holder or works are in the public domain, and a different kind of tool can be applied. And then the last part will be this guided personal project. We'll try to make it work in this setting virtually. Hopefully we'll be able to make it work. So that's it for the agenda. Now I'd like to continue the tradition of an icebreaker. And so I'll ask a question, and if you could answer in the chat whatever comes to your mind, just to get us to know each other a little bit better. It's hard for me, I don't see you, but I'd love for us to connect on this. So I'll ask the question, and then I'll count down from 3 to 1, and then you can all flood the chat with your answers. So my question today is, if artificial intelligence could free you up for 1 hour of your day doing chores in your place, what would you do with that extra time? So imagine artificial intelligence is there to help you, frees you up for 1 hour in your day. What are the kinds of things that you would do in that newly acquired free time? So 3, 2, 1, go. I see there are lots of answers already. Okay. So we have swimming, dancing, listening to music, knitting all the time without breaks, read, row, nice alliteration here, connect with new contacts, pull weeds, read again, go for a walk, spend time outdoors, visit more museums, and go for hikes with my kid. Wonderful. So we have a lot of avid readers who need more time to read. Oh, and someone would like to do more research and take more pictures. So lots of things that we wish we had more time for, and it's nice to know that this there's quite a wide range of leisure activities that we all can enjoy, and hopefully can enjoy more of during the summer. So the goals for today is for you to gain more knowledge about what I've mentioned, which are the 6 Creative Commons licenses and our 2 public domain tools, on how to find and to use CC license works, the considerations before applying a CC license or a tool. We'll take a very short time to look at the CC license chooser, which is a kind of a tool to help you decide which license is best for you to share your works, which license to apply based on what relevant factors, post-licensing considerations. So after you've chosen your license and released content, what you need to be mindful about, and then remixing a work and releasing your remix. So that's what we want to achieve together today. So I'll go straight ahead into the first part, which is the anatomy of the license. And here you can see in this kind of grayscale banner that on both extremes we have what the law gives us, which is that on the right-hand side, you see the copyright symbol. So according to copyright law, any creation which meets the protectability criteria, so being original is the most important one, benefits from copyright protection. So that's the default. That means that any creation, as long as it's original, will be protected by copyright for a certain period of time, then at which point it falls into the public domain, which is on the other end of the spectrum, where there are no restrictions under copyright. So it's free to use by anyone for any purpose. There are no restrictions attached. And Creative Commons licenses kind of sit in the middle of this very wide spectrum, from fully protected, all rights reserved, to the public domain, where there are no rights anymore because they have expired or just never arose. And Creative Commons is this kind of in-between situation where some rights are reserved, but other permissions are granted to everyone. So Creative Commons licenses are a way to kind of navigate between those two extremes and offer this alternative for those who do not wish to have full copyright protection for a variety of reasons. What you can see below this banner are 4 icons. We call them icons. They are very simple representations of the conditions under which users, so others who want to use the content, can use the content that the creator has released openly. The first one is a symbol of a person. That is the attribution requirement. So that is present in every of our 6 licenses. It means that if you use someone else's Creative Commons content, you have to attribute that person. You have to name it. And we'll see in more detail what kind of information you need to share when you want to attribute correctly. The second symbol is a kind of arrow going around itself. It's the share alike condition. This is probably one of the trickiest. It means that if you as a user use content that is available under a share alike license and you modify that content, you adapt that content into something new, that new work also has to be licensed under the same terms as the original one or a compatible license. So it ensures that from the original content, all the adaptations or derivatives, as they're called, follow the same kind of licensing conditions. The third one we see is the $ bar. That means that it's only for non-commercial uses. So as a user, you are free to use it for any purpose in any situation, provided that it's not for commercial purposes, so that it's not for profit or that you don't intend to make any money with it. And the last one on the right-hand side is the equal sign, and that means that there can be no derivatives made. So in most licenses will allow people to adapt, to transform, to create modifications, except those marked with the works marked with this no derivatives icon means that there cannot be adaptations of the work that are shared publicly. We'll go into a bit more detail in the following slides. So here you can see on this slide the 6 open licenses on the top, and then on the bottom, the public domain tools. So this is everything that exists in the CC universe. And you see that the different icons that I just introduced can be mixed and matched in 6 different ways to create these 6 different licenses. There cannot be other combinations. This is all that exists. So we call them by their acronyms. So there's CC BY, CC BY SA, which is attribution and share alike, CC BY NC, non-commercial, CC BY NC SA, so non-commercial and share alike, CC BY ND, so attribution and no derivatives, no adaptations. And finally, CC BY NC and D, which is the most restrictive of all the licenses, but still more open than full all rights reserved copyright. And then we have the public domain tools, which are a slightly different beast. The public domain mark, which you can see on the right-hand side. So it's the copyright sign crossed out. That is not properly saying a license. It does not have the same legal value as the Creative Commons licenses. We call it a label or a mark that is meant to identify content that is already in the public domain. So you can only use a license on content that is currently under copyright, but the public domain mark can be used on content and can only be used on content that is already in the public domain. And on the left-hand side, it looks like a 0 in a circle with a bar through it. That is the public domain dedication tool. And that tool can only be applied on works that are in copyright, so currently protected by copyright, but where the creator decides to release and waive all rights. And this has the effect of placing the work directly in the public domain without having to wait for the copyright term to expire. So this is, like I said, the whole universe of the different tools that we have. The 4 conditions that I've mentioned, as a reminder, are attribution, share alike, non-commercial, and derivatives, and they can be combined to create those 6 licenses. So 4 elements give rise to 6 licenses, and we also include 2 public domain tools, which you can see here along a spectrum. From the most open at the top, which is public domain, and what you're allowed to do on the left-hand side, the corresponding license icons on the right-hand side, all the way down, getting more and more restrictive to all rights reserved, the basic default copyright that the law just gives to every single creator, provided their works meet the protectability criteria. So you will see that the most restrictive of the licenses is the one with the most conditions, the most stringent conditions, which is the CC BY and C and D. You cannot reuse the work for commercial purposes, and you cannot create derivatives, and you have to attribute. The CC BY, you'll notice the attribution requirement is present in every license, so that is included in all of them in any event. And this is just another way to represent that kind of spectrum of openness from the most freedom, which is the public domain dedication, which really releases all the rights into the and releases the work into the public domain, from all the way down to the license that has the most restrictions, and then will give least freedom to those wanting to reuse the content. Now I'd like to just spend a bit of time to go through the anatomy of the license. It's made up of 3 layers. This, what you can see on your screen here, is the machine readable metadata. So there's a machine readable layer that can be read by search engines or other machines that can interpret the metadata, and it's very important to have that layer in the license so that content can be recognized on different platforms through sharing different types of content, whether it's images or videos or other online. So that is the layer that is being read by machines. Then on top of that, there is a legal layer. So that is the legal code. So it's a very long, detailed, written by a lawyer, meant for lawyers and judges. That is the version that is that has a legal value. That is the version that will be interpreted in court. That is what gives the license its power as a legal tool. And then the layer that most people will be familiar with is the human readable version, which is kind of a simplified version of the legal code. And it's a way for people to communicate in very simple terms with reusers what can and cannot be done, but doesn't have legal value in and of itself. Important to know that licenses are perpetual. That means that they last for as long as the work is in copyright. Once the copyright term expires, which is in the US life of the author plus 70 years, the license also automatically expires and the work falls into the public domain. So the CC license is valid until the end of the copyright term, and the permissions given are irrevocable. That means that you cannot unlicense something that you've already released under a CC license. So all the more reason to think long and hard about it. But it's important for certainty for users to be operating in a clear and safe and certain environment, and give them the assurance that if they use CC license content, they can be certain that that permission will be good forever, and that the creator will not come back on its promise and ask for those rights or permissions to come back. So important to keep in mind that once it's released under a CC license, these terms are irrevocable. This is an overview of some of the countries that have copyright laws. Our licenses since the 4.0 version of 2013 are applicable internationally. They used to be different licenses for different countries. You will see that there's still a CC US 3.0 version. We encourage everyone to use the 4.0. The fact that it is applicable across borders is, of course, a huge advantage. There's also been a lot of improvements in that version, but it's important to know that this was a process and it took some time to get there, to make sure that the language of the licenses can actually be applicable depending on the different languages and the different copyright laws of each territory. We have a legal database for those of you who are interested in how they've been interpreted by the courts. We have a case law database and legal scholarship, so a lot of writing has been done over the interpretation of the licenses, especially in the early days when they hadn't been fully accepted, or there were still, I guess, questions about them. Nowadays, I think they're beyond any sort of doubt that they are applicable and that they are enforceable. But for those of you who would like to know a little bit more about their legal interpretation, that database is available. Another important improvement in the 4.0 version over earlier versions, so 1, 2, 3, and the increments in between, is this 30-day window to correct license violations. So if as a user you fail to attribute correctly, or you use a non-commercial work for commercial purposes, as soon as you get noticed from the copyright holder, you have 30 days after discovering it to correct your mistake. So to either, attribute correctly or to stop using for commercial purposes. This grace period didn't exist before. It doesn't exist under the 2.0 version. So if you're using a license under the 2.0 version, you might be even more cautious to respect the rights, because you don't have that 30-day period to correct your mistake if ever you receive a cease and desist letter, for example, from the creator. So now I'd like to spend just a bit of time on CC0 and the public domain mark, which are not our licenses, but our public domain tools. I encourage you to maybe take a screenshot or pause this video if you're watching later. Look at all the differences between the public domain mark and the CC0 public domain dedication. I won't go through all of them today, but it's important to know that they're different and they serve different purposes, but the effect is the same. So the effect is that the work is in the public domain and there are no copyright restrictions, so that the end result is absolutely the same, but the path to getting there is different. For the public domain mark, like I said, it's not a license, it's just a label. It is applied on something that is already in the public domain. to indicate to reusers it's in the public domain worldwide. We can guarantee that this can be reused. And the public domain dedication tool is to be used on works that are currently under copyright, but where the creator wants to release or the rights holder wants to release the work into the public domain. So it can only be applied to works currently under copyright. The effect is the same. So please take a look to compare the two. If ever you're hesitating which one is best, this is quite a useful chart to be able to make the right decision. All right, so moving on to using open content. How do you search for it and how do you discover open content? I looked at this up yesterday. Wikipedia is probably the source that comes to mind first. Has over 6.6 million articles in English alone to date. So obviously a treasure trove of freely accessible knowledge. Most of the content on Wikipedia is licensed under a Creative Commons license, CC by SA, which means that if someone adapts the content of a Wikipedia article or an image or other sorts of content, make modifications, adapt it, that adaptation needs to be shared under the same or a similar license. This is really important for Wikipedia as a movement because they want to ensure that any new creation based on the knowledge that's in Wikipedia is also available as free and openly as possible. So that's, I would say, the reflex number one. You are probably also familiar with Flickr and Flickr Commons, which is its cultural heritage collection. You can see that the licenses are explained on that website as well. So you can filter and look for photos that are licensed under the terms that suit your need. You can also look at websites of institutions, libraries, archives, museums sometimes have their own portal, their own website, their own repository where they keep all the digital or digitized images of their collections. And usually by clicking on the images, you also have the information around licensing. So you know, as a user, what you're allowed to do with that content. This is a list of websites that you can also explore at your leisure. The first four bullets are, I would say, international. They have content from all over the world and are great resources for images, for audio, video files. I invite you to explore them later on. The second two bullets, DPLA and Europeana, are meant to be more regional. So DPLA is for America, Europeana is for all of the European continent. There's a way also to kind of narrow your search depending on what you're looking for. And then the last three bullets are examples of institution portals. So the Smithsonian Open Access Portal, the Metropolitan Museum of Art, and the Cleveland Museum of Art are just some examples where you will be able to find openly licensed images. So that's one way to start. So once you have explored and kind of discovered the content that you want to use, how do you go about doing it? We'll first take a look at attribution, which is, as I said, the one condition that is in every single license. So it's very important that we get this right. I would like to introduce you to the acronym TASL. So TASL stands for Title, Author, Source, and License, which are the four elements of a good attribution according to best practice. So the title of the work might be communicated as a title, or if there is no title, it could just be, there could be a placeholder like untitled, but it's important to give that information so that people can easily retrieve it. the author or the name of the creator. It could be it could also be an anonymous work. In that case, it's important to state that it's anonymous. It could also be a pseudonym or the person's real name. Either way, important to state that in the attribution statement. The source, so that's usually the URL, the place where the image was discovered, and the license. So under what type of license that content is made available, usually also with a link to the license page on the Creative Commons website. So there's absolutely no doubt as to what is allowed under the terms of that specific license. So this is an example of an attribution. And I would like to ask you to share in the chat whether this is right or an incorrect attribution and why. So if we can just take a few seconds to look at it, and if you could tell me if this is a correct attribution according to what I've just explained. So if you can't see what's on my screen, it's a picture of two elephants, and the caption says, "Baby elephants is a beautiful black and white photograph from 2009, licensed under CC BY 2.0. And I already see a lot of answers for the keen observers. There's no author nor source, and yeah, no author nor source. There's depends on what's in the link. That's true. That we see, we can guess that baby elephants is a link, but we don't know what it points to. So excellent. I think we have experts already in the room. So let's move to the second one. So it's a picture of a snow-capped mountain and a sea of clouds at sunset or sunrise. It's hard to tell, but with a beautiful orange sky. And the caption says, "Fogen After Glow" by Lucas Schlagenhoff, CC BY ND 2.0. What do you think about this one? So I see someone answered no source. Not sure if it has a source. It's hard to tell, indeed, because we see that there are links probably with the underlying words, but yeah, we cannot get to the actual website where it was taken from. So indeed, if this was in print format with no further information, the source would be missing. Very good. So let's move on. All right, commercial use. I just wanted to say a few words about that because it can be tricky. Sometimes there's a fine line between what's commercial, what's non-commercial. I guess the answer there is a lawyer's answer, like it depends, and we have to look at the particular circumstances of each case. We have a wiki page that you can see on the right-hand side, which helps to give some interpretation of the non-commercial clause. But yeah, you should always be cognizant of the fact that it can be interpreted differently in different jurisdictions, and so that it's always good to be absolutely certain if, as a user, you want to use a non-commercial work in circumstances that might end in a gray zone. So its aim is to prohibit uses that are primarily intended for or directed toward commercial advantage or monetary compensation. So it's about the uses and not the user. So it could be a nonprofit that is operating for non-commercial purposes, but that does a commercial use, and vice versa. It could be a corporation that, as part of its nonprofit activities, is using something for non-commercial purposes. So it's about the use and not the user, and it has to be primarily intended for commercial advantage. So if you happen to just cover the cost of, printing a few copies, or, if the primary intention is not to make money, but somehow you need to cover your costs, that might not be interpreted as commercial. But like I said, there are no hard and fast rules here, and it's really important to look at the case on a case-by-case basis. We generally would say that this should be used with intention. So as a creator, think about what you want others to be able to do before applying a non-commercial restriction, because it has some drawbacks for the free sharing, open sharing of culture and knowledge, because it creates additional barriers to access. It restricts the dissemination of information beyond its primary audience, right? If there's content that cannot be used commercially, but somehow a commercial publisher wants to use it in an educational resource, it could be a barrier to the spreading of knowledge. It won't be findable on Wikipedia. It won't be available on Wikipedia at all. And like I said, it prohibits inclusion in commercial educational publications, and sometimes public interest, but commercial uses. So something to think about when choosing a license. The other condition that I want to talk about is the no derivatives or adaptation. That's quite tricky. So we'll spend a bit of time to look at the different types of adaptations or reuse that we can encounter and how they differ. So here is a very neat representation of what we mean by a remix on the left-hand side with the pineapple and other fruit smoothie, and then on the right-hand side, the TV dinner. The TV dinner is meant to represent a collection, which means that you collect different works, but you do not mix them together. They stay neatly in their own place. So it could be like in the TV dinner that you assemble different parts of works and put them side by side in an image, or that let's say you take different poems and you make a collection of poems. They're not remixed. The language is not transformed. They're just placed one after the other in a collection. That is a collection and is typically not an adaptation. So you would be allowed to do a collection of CC BY ND works. In this case, the TV dinner is considered an adaptation because Nate, who created this image, added the CC icons onto the TV dinner image, therefore made an adaptation, and this creates an adaptation. But the important thing to remember is that if you don't modify, if you don't mix different works together, you just put them together side by side without them kind of mingling with each other, that's a collection, and that's not an adaptation. On the other hand, the smoothie metaphor is where everything gets blended together. And it's impossible to distinguish the different parts anymore because they've been mixed in together, that often it's very hard to tell the different elements. And in that case, that is clearly an adaptation. And this distinction is important because for works that are licensed ND, you cannot make a remix without permission, but you could do a collection. And then for remixes, we'll take a look at a chart in just a second. You need to make sure that when you remix different elements together, different works together, the license terms need to be compatible together. We'll take a look. Okay, so this is another example of distinguishing compilations or collections versus remix. So these are different photos of guinea pigs. They're clearly separated on the page. There are different descriptions, attribution language on the same page. And it's clear that the different guinea pigs are neatly in their own image and they each have their own license information. But if we look at the following image, we can see that the guinea pigs have been inserted into this beautiful classic painting, and they are clearly mixed in. I think in this case, it's obvious to tell which elements have been added, but you get the idea. They are kind of incorporated into the other work. They cannot be separated. They are to be considered as forming a new whole, and that creates an adaptation. And that's where it becomes very important to make sure that the licenses of the images of all the guinea pigs are actually compatible with the license of the painting. So a few words on non-derivatives that you can find in the CC by ND and the CC by NC ND licenses. So you can copy and distribute a work. That's not an issue, but you cannot adapt it, remix, transform, which includes to translate. So you cannot translate a work that is licensed with an ND license without permission. You cannot update it in any significant way. That would create a derivative work or an adaptation. And an adaptation is a work that's based on one or more pre-existing works, and it will depend on applicable law what exactly is considered an adaptation under copyright law. But the classic example is translating a work from one language to another, or creating a film version of a novel. These are the classic examples. To be protected by copyright, most national laws will require that the adaptation itself is original, so that the creator of a derivative work has to add their own original expression to the original pre-existing work in order for this to qualify as a derivative. So these are just a few examples of things that are not adaptations. So it's okay to do them even though the content is marked ND. So just format shifting. So printing a digital format to a physical copy, that's allowed. Fixing minor problems with spelling or punctuation. Putting works together into a collection, like I explained, like combining standalone essays and an essay collection. That's not an adaptation. Or including an image in connection with a text, like in a blog post. If you want to illustrate your blog post with an image, they're not necessarily merged or blended together. They're just used as an illustration to accompany the text. That will not be an adaptation. So this is an important chart again for you to come back to when you decide to make a collection of different kinds of works. Here, what's important to notice is the NC element is in white, so not allowed. So that's the thing to look out for, is that the NC restriction will prevent the use of NC works in a collection that is not also licensed NC. This is the remix matrix. You can see that it gets more complicated when you try to mix 2 or 3 different or more works together. You need to make sure that on both sides, so all the works that are mixed together are compatible. And by using this chart, it can be pretty easy. You will notice, for example, this column of X's. That's of course because ND doesn't allow any remixes. So it's clear that you cannot remix it with anything. The same with the last column, by NC ND also has the ND requirement, impossible to use in the remix. So take a look at this when you have a bit more time. This is also a different representation of the same matrix I showed you. The parts in yellow are quite interesting because even though it's yellow, it's more like a gray zone. It means that it depends. There could be some circumstances where it's a little bit trickier and we need to look at it a little more closely. So the share-alike condition, like I mentioned, is to make sure that the works that are adapted from the pre-existing work continue along the same kind of openness path, and so they are shared along the same kinds of license or compatible license. So by SA or by NCSA are the 2 share-alike licenses by essay is the one that is used on Wikipedia. I see that there's a question in the chat. I can read it and try to see if I could answer it now. Otherwise, please keep them or write them in the chat, and we'll take them at the end. All right, so there's a question. Is the attribution always for author of the first original work or attributed to the author of the adaptation? Yeah, that's a very good question. In that case, you would probably need to attribute both. So if there's been an adaptation, usually that adaptation will have its own attribution language, and that attribution language will include the reference to the original work. So if the adapter has done their job properly, there will already be the attribution information from the pre-existing original, the first work that was used for the adaptation. And if not, you as a reuser of the adaptation, if you want to do it properly, yes, you would have to give attribution for the adapted work as well as for the original one.
Brigitte, we also had a question, I think, that just came to me, but Robert asked, is a link sufficient as a source? I would think not necessarily, because links change, go bad, expire, unless it's some kind of permalink. It seems like a best practice would probably be to actually give a proper citation for the source of the material. But I wonder if you could share a little bit more about that, since that certainly came up in the sort of quiz you gave us.
Yeah, no, definitely. And especially if we're talking about printed resources where a link might be, as a hypertext would not be visible in print. So yeah, I think the best practice is to provide the URL, but you're right, there's this problem of link rot, and sometimes links just don't work. But yeah, the more information you give, the better. There is no limit as to how much information you can share. Sometimes it's not very practical to have like a whole page of of attribution. But yeah, what is reasonable, and like I said, the minimum is to provide the source. Usually we advise on the URL. I think you point to an important issue, which is what if the URL doesn't work? So giving more information, maybe the name of the website, or pointing to other kind of clues to help people find it again would be my advice. Would you repost the symbol meanings again? Okay, let me try to go back. I'm not sure I can go back.
Mike just posted a link.
Oh, okay, fantastic. Because I'm worried that I'm gonna get lost in my my slides if I go back. But yeah, the 4 icons: attribution, share, like, non-commercial, and non-derivatives. And thank you, Mike, for sharing this link. Any other questions before I move on? Okay, lots of ground to cover still, so I better move on. Important consideration is you must own the copyright in the work if you want to apply a license to it. So you cannot just go on the internet, find an image, and randomly decide that you want to license that image under a Creative Commons license. Only the copyright holder, so that's usually the first creator, the author, or if it's been assigned, or if for any reason the copyright holder is somebody else, that is the only person or entity that can apply the Creative Commons license. And like I said, that permissions are irrevocable, so it's really important to make a clear and informed decision when applying a CC license. Here are just a few questions to consider. Lots of text on this slide, but imagine what you would like people to do with your work. Would you allow them to do adaptations? Would you like them to be able to translate what you write into different languages? You want them to make remixes with guinea pigs, for example. If that is your intention, then you should choose a license that allows your work to be adapted. So you shouldn't go for ND. A second consideration, is if you want your images or your content to be incorporated in Wikipedia or other free knowledge resources, then you have to use licenses that are compatible with their terms, which is for Wikipedia CC BY or CC BY SA or even CC 0, because Wikipedia will not allow anything that's more restrictive. So if it's non-commercial, it won't appear on that website. And then if you want to give away all your rights so that your work can be used by anyone in the world for any purpose, then you might want to think about using the public domain dedication tool, which really lifts all copyright restrictions. So depending on your intention, you can ask yourself these questions to help you go through the chooser. I think in the interest of time, I will skip going through the license chooser, but if you go to that website, so creativecommons.org/choose, it will walk you through the motions to decide, depending on the type of work, the purpose of sharing, and what you want others to be able to do with your resources. It will indicate to you what is the best type of license to suit your needs. I really encourage you to play with it. Sometimes we do a little game here. I'm afraid we don't have time, but think about just taking a picture real quick with your phone, and you deciding to share it. Go through the license chooser and look at your picture and try to think about what you would want others to be able to do with that picture, and how you would be able to then determine which license is best for you. This is what it looks like, at least in the beta version. So you can really follow all the steps. It's quite neatly done. Can go at your own pace. The first question being, do you know which license you need? In that case, you don't need to answer all the questions because they've been answered. But going through all the terms, whether they are important to you or not, helps you decide which license is most appropriate. So this is what I wanted to do with you. I can share the idea with you, but I think we don't have time because there's only half an hour left and there's still lots of things I would like to do with you. But the idea of this game is that you take your phone, your smartphone, and you take a picture of your keyboard, whichever way you want. So think about the angle, the lighting, the parts of the keyboards you want to photograph. Think about what would make it an artistic work. And then once you have that image, go through the license chooser and decide under which term you would like to release that photo. And I think it will trigger the questions that I've been, throwing at you a little bit abstractly. But once it's your own creation and you're about to release it into the world, these questions become a lot more present, and it really helps to kind of understand, well, okay, I understand this will be the impact if this is being licensed openly. So maybe in your free time, if you're inclined. So how do you apply a CC license to your own work? Well, you can go through the license chooser. You can also go to one of our wiki pages, which is about marking your work with a CC license. So depending on the type of work, you might want to mark it differently. So you cannot communicate information about the license the same way in a podcast, as in a video, as in a blog post, or just by sharing an image, right? So it gives you some tricks on how to make sure that that information gets to the user in the most efficient and clearest way possible. So for example, when we were just talking about this, so you need to ensure that you have a working link to the corresponding, the source, but also the license on creativecommons.org, so that even if you put CC BY, it might be enough, but putting a link to the license for those who are not familiar with CC BY can lead them to the human readable explanation and be a very efficient way for people to know much faster what they can do. To spell out the URL of the license, if you choose for image-only formats, So not just the hyperlink, because that gets lost, but really to spell out the whole address. You can add bumpers or short sections at the beginning of and end for videos. So if you're going to share this video on YouTube, for example, you could start with a buffer. This is licensed under CC BY with proper attribution. And then if you're doing a podcast, for example, you could read aloud, this podcast is released under da license, so that the information is communicated, whatever the format. So to recap, well, I advise you to use the license chooser to determine which CC license best meets your needs. And if you can apply the license code, so that is the lawyer version, so to speak, the full document, or to copy paste the text and the links provided so that all the information is available to reusers. If you're using an online platform, sometimes they have a built-in CC license tool. So if you're uploading to YouTube or to Wikipedia, for example, they will have a form and a tool to help you choose the correct CC license. And of course, give the attribution information that you want others to use very clearly when you release your own work, so that it makes it easier for them to just, copy what you've created for them, and makes it a lot easier for them to respect this tassel approach. Now, after licensing, things to consider after it's been released. So when you're happy with your work and you're happy with the type of license you want to use, and you go for it, you release it into the world, you might be tempted to kind of change or customize the license terms. We advise against that. So some might be tempted to use a CC license, but add another clause just because they want to make sure that it tackles this other issue that they have. So we advise against customizing a CC license because it adds a lot of confusion. The CC licenses are, like I said, understood across the world. And so it's important that we don't create different kinds of CC licenses beyond the 6 that are the 6 official ones, because it will require people to really go into the custom terms and understand what's the difference between the standard CC license. So it's just another kind of barrier for people to be able to reuse this content. And it basically eliminates the benefit of standardization, which is the beauty of Creative Commons licenses, is that once you know what the icons mean, you know what you're allowed to do with them as a user, and you don't have to go and read the fine print because it's standardized. A few words about selling CC license content. We don't advise putting CC content behind the paywall. That would go against the spirit. It defeats the purpose of using the free license. So this is not something that we recommend. And I want to just highlight that sometimes there might be different markets for the digital or the physical version. So you might want to release, let's say, a publication, a book, digitally, and sell physical copies. It's possible to sell the physical copies, but make the online version really accessible. So there are ways that you can see how to still recoup your investment, but at the same time ensure that it's still openly accessible according to the terms of the license. Like I said, changing your mind about the CC licenses, it's rare, but it can happen. The licenses are irrevocable. So I want to say tough luck, but you can still offer it under a different license. So let's say you went for a very open one and now you think that you won't want to restrict it. You could go from CC BY to CC BY and C, but people who find the CC BY one will still be able to use it under the more open, least restrictive licenses. So you cannot go back on that. It creates confusion to have the same work under different licenses. So we're really against it, but we can understand that some circumstances would call for this in very rare cases. You could also decide to remove the online copy if it's really something that you regret releasing. Just remove it from where you posted it. But of course, if somebody else finds it from another source, that can also, that could be a little bit trickier. Maybe another time for questions or just a breather, because we have about 25 minutes left.
So Robert has another question that came to me. He appears to be direct messaging me alone, but this came through just a few minutes ago, saying it seems complicated. If people are already abusing the standard copyright, why would those people suddenly comply with Creative Commons?
Well, they should comply because they are enforceable. And as the licensor, as the creator who licenses the works out, you can enforce your licenses in court. So it's like a contract that you as a creator have with anyone that uses your content. So they have an obligation under law to respect the terms of the license. Otherwise, it's considered copyright infringement, and you can go to court. But of course, copyright infringement is hard to police. I understand that there's lots of things happening online, but there are very effective ways to make sure that the terms are respected, and that is by going through either the classic court actions or to go through a more amicable path. So to send a friendly letter saying, I noticed that you misuse my content. Here are the terms. Could you please use the work under the terms that I've agreed to? And if that doesn't work, going with a firmer tone every time. But there's also alternative dispute resolution mechanisms like arbitration or mediation that can be a little bit lighter in terms of cost and time, and can be an effective way to resolve a dispute. But that's one of the huge strengths of the licenses, is that a violation of the license is copyright infringement. Okay, so there's another question. How do you put the legal part onto the license? Cut and paste from your website? If there's time, can you speak more to how you would license the same work differently for online versus a publication? Example, online open access journal with a printed version for members only or subscribers. Maybe I wasn't clear about this. So yeah, for your first question, you wouldn't be expected to copy the whole text of the license. A link to it, or the human readable version, which is usually quite succinct and can be easily accompanied by, can easily accompany the work. So you wouldn't be expected to copy the full length of the whole contract. And as to your second question, I was not clear, but I didn't recommend that we use different licenses for the same work in different formats. But if the same work is still licensed very openly, there could be a way to kind of charge for a physical copy if you want to cover the costs of the printing process, for example, or the shipping piece. So what I mean is that the fact that you sell some copies but make others available freely is not incompatible, and can still be done if you incur any fees for, to help in the dissemination of your work. All right. Any more questions? Okay, so we have about 15-20 minutes to do this this little activity that I planned. So we're gonna have to speed through it, but hopefully there's still time to go through it. So what I thought of doing together this afternoon is to play around with openly licensed images, to remix them with the objective of raising climate awareness. So I'll explain in a minute what the activity is about, but that means that you will have to become active and get your creative juices flowing for these last few minutes. I will show 3 images. This is the first one. You can see it's an under the sea kind of scene with fish and coral and other sea creatures. The second one is the mountain glacier. And the third one is a woman sitting on a dune looking at the sunset on the sea. So these 3 images have different permission according to the kind of license that they are made available under. And the purpose of the activity is for you to choose one or several of these images and create your own poster for climate awareness. So use an openly available image, remix it, adapt it, add new images over it, or text, or make any modifications that you want. And the idea is that at the end, you will have your own poster with the image that you chose, the transformations that you made, and this nice message about raising awareness for climate change. So these are the 3 images. So what I've done is I've created another slide set, which I'll share the link to in just a moment. And that will give you access to another slide deck where the 3 images are copied. And what I would like you to do is to duplicate the slide that you want to work on. So we make sure that everyone can use at least one of those images as a base. So here is the link in the chat. I will meet you there in a second, which means that I will need to stop sharing my screen for 2 seconds while you all open the new slide set. And I will find you there. Okay, I see many of you are already in there. That's fantastic. So I will just share my screen again. So this is the first slide that you should all be seeing also on your end. And on this slide, I have tried to write down the instructions as clearly as possible. So I will repeat them. And the goal is to create a poster to raise awareness about climate change. So in this slide set that I just shared with you, duplicate the slide with the image that you want to remix. So that's usually right-click, duplicate when you're on the left-hand side where you see the slides in a smaller format. You can right-click and duplicate. It will create a copy right underneath. Optionally, you can decide to add your name in the speaker notes space so that you can remember which one is yours. We won't have to share this. It's really up to you if you decide to share them afterwards. But for the purpose of this exercise, it would be nice if you could remix those images by either adding other images, and there you have to be really careful about the permissions. Make sure that you are allowed to do them under copyright. You can add text, or you can adapt or modify the image. Be creative. Then you need to give a title to your poster so that people can attribute that back to you. Then I don't think we will have time, but we need to go through the exercise of choosing and applying a CC license. So you as a creator of this derivative work, what kind of CC license would you like to apply? And then it's up to you if you want to share your poster with the world. So these are the instructions. I'll show again on my screen the 3 images that you can use with the corresponding license information. And then we have, let's say, until, we have about 8 minutes let's say, to be creative and create those derivatives. And you need edit access. Oh no, I thought I had given full access. I'm sorry about that. So I'll change it right away. It's just taking a bit of time loading. I thought I had given full permissions. Copy link. Okay, please let me know if this one works. Oh, I shared it only in private, sorry. Does it work now? Ah, I see some images are being duplicated. Is there a particular way to do the editing itself? I don't have a lot of skill in digital art. Yeah, neither have I. So it could be that you just use the tools from Google Slides. You can add, let's say, like a speech bubble, or just add text. You don't have to do anything complicated. You could also just decide to add shapes around it. For those who have more time or want to explore how to do this with even more tools, you'd be welcome to do that after this webinar, and then I'd love to see the results. So if we don't get a chance to see them before the end of the webinar, feel free to email them or to share them with Mike, so that we can show how creative we can be in just 8 minutes. But yeah, time is passing, so we'll work in silence for, I guess, another 5 to 6 minutes, if that's okay. And then we'll come back and you can either present what you've created or we can talk about it. But we'll get back here at 2024. It's a weird time to come back, but gives us a bit of time to debrief afterwards. Now I'll stop sharing my screen. Are people allowed, able to duplicate? Maybe it's a bit tricky, yeah?
I think you shared the link to the actual presentation and not the
Oh no.
duplicated one.
Oh, no. Okay. Oh yes, now I see what I did. Okay. Sorry.
I'm just
Go
having
ahead.
flashbacks to the Creative Commons certificate course that I took twice, and like just taking hours to do this. Not 5 minutes.
Not 5 minutes.
Right.
Yeah, so I
There we
just
go.
changed the restrictions. Sorry about that. That's why I wasn't seeing them in the right slides. But I guess it doesn't really matter. I can combine them at the end. So another 4 minutes for people to do this really quickly. So it's like an exam, I would say, pencils down. It's already over, and it went by really fast, but I can see that there's already a lot of really cool creations in the slide with lovely images and speech, and people have really done amazing work in such a short time. So is there anyone who would like to speak or chat about their own creation? And if you want, I could also display it, but otherwise, maybe just talk about your experience and how it felt, and especially if you had any thoughts about choosing the right license or anything linked to that. So I would love to hear from you in the few minutes that we have left. Any volunteer?
I cheated and made sure I used everything. I used the open verse, and looked for anything in the public domain, so I didn't have to worry about licensing. I know that just to be quick.
Yeah. That's a very good reflex. If you want to be sure and not have to assess any risks, that's the way to go.
I had an issue.
Mm-hmm.
Just as I was finishing, I realized I wanted to put something over like where the copyright information was on the original picture. And I'm like, no, have to leave that alone or have to copy it somewhere else in that case. Like, no, my art, my beautiful art.
Yeah, and like we said in this presentation, sometimes putting it on the art itself, the attribution language is not the best part, is not the best place, because it can simply just not look nice, right? You don't want this to be on the work, but it could be next to the work. So an alternative could be, like in this case, we're using Google Slides, right? It's not the most fantastic tool to be creative, but you could put it in the speaker's note so that at least it's somewhere near and people could refer to it, but it doesn't have to be necessarily prominent on the work, because in some situations you wouldn't want that to be visible. It would clash with the artistic purpose. Any other feedback or reflections?
Yeah, hi Brigitte, it's Tina.
Hi.
I noticed that I couldn't do anything to the image itself, the original.
Because of the format.
Because you set it up that way. Okay.
Yeah,
Okay.
yeah. It's
Gotcha.
yeah, exactly. It was just an image pasted onto the slide itself. So you would need a different kind of tool to be able to modify the image itself.
Okay.
Any last comments or?
These are great. Mine was like I was trying to be annoying and make like a big banner that like from like 1995 Word that just like said something, but people actually did very thoughtful things. So this is great.
Yeah, so take a look. This, we don't need to make this available. This was really just for the exercise, so don't worry about us sharing this. It will stay within the confines of this webinar, but the goal of this exercise is to kind of give us a firsthand experience of what it is to use someone else's work and making sure that we respect the conditions under which it has been shared, and then creating our own work where we as a creator also have to make a choice about how we want to share it with the world, and making sure that we communicate that very clearly. And some use Photoshop. That's also a great way to enhance your creativity. So I'll hand back over to you, Mike, because I think this really brings us to the end of this session. I just want to say thank you very much to everyone who was here for this session, for the previous session. It's really been a pleasure to participate in this series.
Yeah, thank you, Brigitte. This was great. We worked on this for a long time, had a lot of meetings to get this done. So this is really great. I'm glad that we were well attended. I'd like to thank the CLHO for hosting us and for sending out the communications and the registrations and putting the videos online, which will be made available. So find out for more information from that. This is only the beginning of our kind of IP work, like I said. So keep an eye out for more information from Connecticut Humanities, from the League, about things coming up around this. We're going to meet in the summer and figure out some more programming. You can find my information at the IP page of Connecticut Humanities. It's mcamesis@cthumanities.org for any kind of copyright IP questions. So thank you. Thank you, Creative Commons. Thank you, CLHO. And I'm going to toss it over to Emily and Amherst for any final housekeeping thoughts.
Sure, thanks, Mike. I mean, I would just say, and I'll pop it in the chat, if you have program ideas or things that you'd like to see from the League, we're always, looking to make our programs responsive to your needs out in the community. So you can email Emily as our membership and programs coordinator with your ideas. And I'll pop a little message with her email address in the chat. I don't know. Oh, there you go. Send them to Emily. We regroup routinely and talk with CTH about programmatic support that we can offer. So we really welcome your ideas and want to know how we can support you better.
Thank you, Imris. And just to close out, just a reminder to everyone, this is recorded. So be on the lookout for an email from me. I will attach the recording link for this session as well as the previous 2 sessions in case you missed those, and you'll have them to access on our YouTube channel as well. So thank you so much to Mike and Brigitte and Creative Commons for having us host this program. I hope that it was beneficial to all of you, and I look forward to future programs down the road. So thank you, everybody, and have a great rest of your day.